Hello friends, welcome to Shriram's. The topic for today's discussion is Indira Sawhney Judgement, time to revisit the 50% cap on the reservations. Backstory. The Supreme Court last week said it would also hear arguments on the issue whether the landmark 1992 judgment in the Indira Sawhney case would be re-looked at and referred to a larger bench. The verdict in the case of Indira Sawhney versus Union of India, also known as the Mandal verdict, capped reservations at 50%. What is the story behind the Indira Sawhney judgment? The genesis of the case lies in 1980 when the Second Backward Classes Committee, headed by B.P. Mandal, submitted its report. The report recommended 27% reservation for other backward classes and 22.5% for the scheduled castes and scheduled tribes. The central government issued an office memorandum providing 27% vacancies for socially and educationally backward classes to be filled by direct recruitment. The announcement sparked large-scale protests across the country. Another memorandum notifying an additional reservation of 10% for other economically backward section was also issued subsequently. What was the court's ruling in the case? The 9-judge bench headed by Justice B.P. Jeevan Reddy heard the case in the Supreme Court. The Supreme Court, in a 6-3 verdict, upheld the 27% quota for SEBCs but struck down the 10% quota based on economic criteria. It held that a backward class cannot be determined only and exclusively with reference to economic criteria. It also told the centre to evolve to exclude the creamy layer from the ambit of reservation for backward classes. What is the 50% rule of the Indira Sawhney case? The judgment laid down that the extent of reservation should not cross the 50% limit, unless a special case was made out of extraordinary situations or peculiar conditions to relax the rule. The court, however, did not explain why the cap should be set at 50%. It termed 50% cap as reasonable and said that any reservation beyond 50% would be liable to be struck down. How can the reservation over 50% be justified according to the court? The apex court in Indira Sawhney held that every reservation over and above 50% must be based on valid grounds which will have to be specifically made out. The adequacy of representation is not to be determined mainly on the basis of overall numerical strength of the backward classes in the services. For determining the adequacy, their representation at different levels of administration and in different grades has also to be taken into consideration. In the words of the court, it is the effective voice in the administration and not the total number which determines the adequacy of representation. Why does Tamil Nadu have 69% reservation? Tamil Nadu ensured that Supreme Court's judgment did not weaken its reservation system, which was more extensive than anywhere else in India. The States Assembly, which passed Tamil Nadu backward classes, scheduled castes and scheduled tribes, reservation of seats in educational institutions and appointments of posts in services under the State Act 1993 to keep its reservation limit intact at 69%. The law was subsequently included into the 9th schedule of the Constitution through the 76th Constitutional Amendment passed by the Parliament in 1994. Has the 50% cap been violated in other places in India? Maharashtra granted 16% reservation to Maratha community in 2018 over and above the existing quotas. Though the Bombay High Court upheld the law, it reduced the quota limit to 12% in employment and 13% in admissions. Several other states have also exceeded the 50% limit on reservation, including Haryana at 67% and Telangana at 62%. The constitutional amendment providing 10% reservation to economically weaker sections has also brought the level of reservations to 60% now. Well, that's all for today. I hope you enjoyed today's podcast.